Welcome to Case Series. Don't forget to like, share, and subscribe for more courtroom drama.
Hi, Ms. Patel, today's date and time set for your arraignment. I see that you've requested a court-appointed attorney.
I'm requesting court-appointed attorney.
All right, sir. Then I'm going to go ahead and arraign you myself. Ma'am, you understand that you do have the right to remain silent. Anything you say can and will be used against you at trial. You also have the right to an attorney. If you cannot afford an attorney, one will be appointed to you by the court at public expense. Do you understand those rights?
I understand.
Okay, that's good. So it is alleged that on July the 4th, 2023, that you violated City Ordinance 32-277, which is commonly known as disturbing the peace. That is a misdemeanor punishable by 93 days in jail and or up to $500 in fines. As to that charge, I'm going to enter a plea of not guilty. Say again?
Welcome back to the Courtroom Chaos Files, where logic takes a back seat and entitlement drives straight into a wall. Today's episode isn't just another legal showdown. It's a double feature of pure delusion. First, we meet Miss Patel, who treats a misdemeanor arraignment like a personal insult. Then we travel south to Okaloosa County, where Miss Null delivers one of the most baffling monologues you'll ever hear in front of a judge. Both of them prove one thing: confidence without comprehension is a dangerous combo. Stay tuned, because what you're about to see defines the phrase, "You can't argue with the law."
Misdemeanor punishable by 93 days in jail and or up to $500 in fines. I'm entering a plea. Ma'am, stop. Ma'am, stop interrupting me, okay? I'm entering a plea of not guilty on your behalf. Okay? I'm going to set this for a pretrial, all right? Now, would you like a court-appointed attorney? No? Okay. All right. So I'm going to set this for a pretrial. As for your bond, I'm going to set your bond at $250. Cash or I'm going to set your bond at $250 cash or ma'am, stop interrupting me. I'm just trying to tell you what your bond is, okay? All right. No leaving the state of Michigan without the consent of the court, and no contact with the victim locations. All right? And we'll see.
From the moment Miss Patel steps up, the judge is calm, patient, and fully in control. But notice her body language, rigid posture, narrowed eyes, and that frozen smile of disbelief. She's not processing the legal rights being read to her. She's preparing her rebuttal. This isn't confusion, it's defiance. Judges see this often. Defendants who believe the courtroom is optional, and the law doesn't apply to them. But here's the twist. Once you challenge the judge's authority, you lose the only person who can show you leniency. Patel's silence isn't submission. It's the calm before the storm.
I'm going to enter a plea of not guilty on her behalf. Again, request 15 days for any pre-arraignment motions and demand trial by jury.
All right. Thank you. Brandon Pursley is next.
Oh, I'm sorry, Judge. They brought out. Are you Ms. Pursley?
No, I'm Noel.
Yeah. They brought up Miss Knoll. I'm sorry.
All right. You pled her not guilty, didn't you?
Oh, okay. I maybe misunderstood. I thought that you were saying that I was talking on behalf of the wrong person. I apologize. All right. Thank you, ma'am.
Oh, okay. Can I ask how it went? I'm not sure what happened.
He pled you not guilty.
So what
And
happened from there?
we got a pretrial set for August 28th. If he can get it resolved sooner, I'll bring you in sooner.
So can I get out of jail today?
Well, I guess there's been a bond set for her, hasn't there?
Correct. It's 1,000, 10% of 1,000.
And there it is, detonation. Patel interrupts the judge mid-sentence, mid-word even, as if cutting him off could rewrite her charges. What she doesn't realize is every stop interrupting me from the judge is a flashing red light. This isn't a YouTube debate. It's a legal proceeding. When she refuses to listen, the court's patience evaporates. The judge's tone stays measured, but legally speaking, she's skating on thin ice. A $250 bond is lenient, but her attitude? That's what raises eyebrows. Watching her argue is like watching someone pour gasoline while holding a match.
If you make bond, you can.
Okay, is there any way I can get, okay, so I have a lot of information in this packet about how your facility, not technically yours, but how this facility has been very wrong to me. And I'd like to give it to my lawyer or my attorney.
You certainly may, ma'am, absolutely.
Thank you.
Okay?
Thank you.
Going to be contacted with somebody else by somebody else that we've contracted with to do an evaluation on you, and just please be cooperative with them. It'll be a Dr. Zeman.
Is there any way that I can get this information looked at today while I'm still in here? Because last time I was in here.
And this is not your trial date. This is just arraignment.
Okay, well, I never got to see my attorney on
No,
this.
ma'am, that's not true. I saw you on June 22nd of this year at the Escambia County Jail.
Yes, sir, but I did ask to see you again, and you did state to me out of your own mouth
And you
that I
will.
would see you before I went to my arraignment on today, the 6th.
Well, ma'am, then I apologize. I don't remember saying that. Normally, after I've seen somebody, I don't need to see them again before arraignment.
All right, well, he's working on your behalf because he's pledging not guilty, and he's taking your information, which he's going to review.
I understand that. All I know is I don't get to. I'll come out in just a second. 1 second. I promise I'll comply. I don't get to talk to anybody in jail, which I still am because I'm still shackled, still in cuffs. I'm still in my uniform. I've been on the loaf since June 4th. I'm a pregnant inmate. Had a period twice for which.
And as Judge Slavin calmly moves on, it's remarkable how unshaken he remains. He's been through this before, defendants who think volume equals validity. But here's the subtle brilliance. Judges like Slavin never mirror the chaos. They stay cool because emotion equals weakness in their world. Patel's mistake is turning the courtroom into a power struggle. But this isn't customer service. It's criminal procedure. The more she pushes, the more credibility she loses. It's a textbook example of why the phrase, less is more, should be printed on every courtroom wall.
It's medical. They refused me medical. I have a sitcom plus notes written in that envelope stated to whom it may concern, which is my attorney, along with his business card. So that states that I did see him and I did ask to speak with him before I came to court today. I would like to know why I'm being treated so unfairly and why it is that I don't get to speak with anybody of power except, of course, your COs who don't like to be at my liberty as an.
Now we shift scenes from Michigan's controlled chaos to Florida's full-blown confusion. Enter Hannah Null, the second contestant in our Karen Olympics. At first glance, she seems calmer than Patel, but don't be fooled. Her meltdown builds slowly, like a hurricane forming off the coast. Within minutes, she's questioning the process, her own lawyer, and even basic courtroom procedures. This is the classic Karen maneuver. When logic fails, pivot to victimhood. What's fascinating here isn't just her words, but her certainty. She's wrong with absolute confidence, and that's when it gets entertaining.
By my inmate number, therefore I have all my rights that I had coming into jail. I'm 21 years old. I had a clean record before I entered this town in last year, the end of last year. What I want to know is how I assumed 2 misdemeanors and a felony in this town within a month and a half of each other. And I managed to keep a clean record my whole gosh darn life.
Very good.
Food for thought.
Your attorney's pledging not guilty. Thank you. Next.
But I'd love to